We know how much you all like free legal advice. When you email us your questions, Dave Hollingsworth is happy to answer them. He's with Leanne Cusack in studio. Leanne.
Yes, we have David here, and we have a long list of questions to answer, but we always like to tackle a topic. And the topic today, David Hollingsworth, is relating to lawsuits involving children, or as deemed by law, anyone who's considered a person under a disability, and what we need to know. So that's how the law describes children, or
any individual who's mentally or physically incapable of acting for themselves.
So these situations would be?
Well, I mean, anytime there's a child or anyone under a disability involved in a lawsuit, our courts have gone to great lengths to try to protect their interests, and it's governed by Rule 7 of our Rules of Court. And so one of the key features is that anybody who is under a disability requires a litigation guardian. And a litigation guardian typically is an adult family member or a parent, or if neither of those are available, in the event of somebody who's got the mental physical incapability, the public guardian and trustee, or for a child, the children's lawyer. These people act on the party's behalf, and they make all of the decisions for these people.
So this could be anything from a child throwing a ball and breaking a window to a child who's actually involved in a motor vehicle accident. Now, this doesn't relate as much to custody, or?
Well, anytime a child is a party to a lawsuit. And so typically, you know, they'd be a plaintiff if they've been hurt, but, you know, they may be a defendant if, like you say, there's their allegation of vandalism or something like that. But in any event, they have to have a litigation guardian represent them, and that person makes all of their decisions for them. And one of the key features of a litigation guardian is that because they're making all of the decisions, they are actually personally liable. If they pursue a lawsuit and the child loses, they're personally liable to the other side for their legal costs. But assuming everything
That's pretty important. Explain that again.
Well, I mean, typically the person who loses in a lawsuit is going to be responsible for the lawyer's fees of the other party. And so if you are the litigation guardian for a person under a disability, then you are potentially on the hook for all of the legal fees incurred by the other side.
Okay, and we're talking about children, but as the law reads.
Right. Yeah, sorry.
As the law reads, so children or anyone a person with a disability.
Yeah, a person who's got a mental or physical disability and they can't act for themselves.
So that's our lesson for the day. We have 2.5 minutes for our first segment to go through some rapid fire legal questions. You ready?
Sure.
Okay, it's like a game show, isn't it, David?
Yeah.
All right, first one, I'm going to start at the bottom of the list. And since we were talking about children, what is the difference between child custody and child access?
Well, child custody, assuming it's a parent who's got custody of the child, they typically make all of the, I guess, important decisions, schooling, medical decisions, sometimes dealing with things like religion and stuff like that. Whereas the parent who has access, they get access to visit with the child, and they are entitled to all of the information related to these important decisions that the custodial parent makes.
Next up, this relates to your personal area of expertise, which is personal injury.
Right.
My wife was at a store, reached up for a vacuum cleaner, 3 huge boxes fell on her head and hit her. They've offered a $2,000 settlement. Does this seem reasonable? Should we get a second opinion?
Well, assuming you can establish liability, in other words, that the boxes were somehow dangerous, which maybe they were, what you do is you get a medical opinion. I mean, what are the injuries? What is the diagnosis? What is the prognosis? Is there future care? I mean, you need to get a lot of information before you can determine what a case is worth. So my guess is that, yes, you probably need a more detailed opinion than that.
Because you don't know what ongoing injuries could be.
You don't know what the extent of the injury is.
Now, this is a question, and it's so important, and we'll emphasize again, the importance of having a power of attorney.
Right. Well, sure. I mean, you know, there are two types of powers of attorney. One of them is for your personal care, and one of them is for the decisions related to your property. And this is while you are alive and for whatever reason incapable of making these decisions, you've appointed somebody else to make them for you.
If you don't have a power of attorney?
Well, if you don't have a power of attorney, and let's suppose you become incapable somehow, an application is made to the court, a guardianship application, and it's made through the Ontario Public Guardian and Trustee, and either somebody is appointed as your guardian or the public guardian and trustee takes over.
Well, this question was, what should I do if my sister is incapable of taking care of herself and there's no power of attorney?
Right, so you would probably get a lawyer to help you out with a guardianship application to the court, and assuming you want to be the guardian, you ask the court to allow you to be the guardian to make
So
these
you have
decisions.
to go through the court to apply
Yeah.
if, in fact, your sister does not have the power of attorney, and you would have to show why you're the appropriate person to do that.
Yeah, correct.
We're going to be back, and we're going to move on from power of attorney, Michael, to living wills and a lot more.
Well, back to Leanne now with lawyer David Hollingsworth, who's serving up some free legal advice.
And Michael, it's really interesting when we have David Hollingsworth in the studio. The commercial break, where there are sort of a steady stream of questions from staff. Those of you who don't work in the building have emailed your questions. So if you're ready to answer these after you've answered all of the ones off the clock, that's great.
Yeah, bring on.
This one is a personal injury one.
Okay.
Someone was injured at work.
Yes.
The question is, do I go through WSIB or do I sue?
Well, sometimes you can sue, sometimes you cannot. If you're injured at work in the course of your employment and the cause of your injury is your employer, and you are what's called a Schedule I employer, which is basically not a government employee, then you cannot sue. You can't sue your employer. And if you're hurt by somebody else who's a Schedule I employee, you can't sue them either. So there are kind of specific cases where you can sue, where let's say there's a third party involved and they injure you, then maybe maybe you can sue them. But you've got to make your election between WSIB and a lawsuit within 3 months of the injury.
Within 3 months?
Yeah.
Okay, that's important to know. Now, this relates to work as well.
Okay.
My boss gave me a letter telling me basically things weren't working out and fired me. Is my boss able to do this without warning?
Yes, but the boss has to provide you with adequate pay in lieu of notice. So the governing factors there, you've got the Employment Standards Act that says it's basically 1 week of pay for every year that you've been there. Although the courts have broadened that and they say it's roughly about a month of pay for every week that you've been there. And there are certain factors that are considered in either raising or shortening that amount of time. Like if your boss, announces it at a Christmas party or is making fun of you, or if you're the last one to find out and people are whispering by the water cooler, they may be things that embarrass you in particular, then the amount of money they have to pay you goes up. If you've got a job that's really hard to replace out in the workforce, then the amount of notice may go up. If you're of a certain age and it's going to be that much harder for you to get out there in the workforce, then the amount may go up. So there are certain factors that come into play in assessing it, but the rule of thumb is Employment Standards Act, they owe you a week, and the common law says they owe you about a month per year of service.
And then it's going to be a different perspective, of course, because the boss will argue for the week,
Sure.
and then,
Yeah, the boss argues the week and the employee argues the month, and you take it from there.
We have land transfer tax questions. We have injuries in another province questions. All right, I just bought my first home.
Yeah.
What is land transfer tax? How much is it? And are there other hidden costs?
Well, land transfer tax is exactly that. When you're the purchaser, you pay a certain tax. It's to the provincial government, and it's broken down. The first $55,000 is 0.0 or 0.5%. Between 55 and 250, it's 1%. 250 to 400, it's 1.5, and 400 and over, it's 2%. However, you get a $2,000 rebate if you're a first-time home buyer in Ontario. Other costs, there are tons of other costs. There's a title search, there's title insurance. It costs money to register the transfer on title, the mortgage on title. Typically, the disbursements far exceed the legal fees in a transaction of real estate in Ontario.
And I think people see that all the time. They kind of look at what buying a home is going to cost without factoring these costs in. So.
Yeah, hopefully the realtor points that out to them. There's also the real estate commission if you're selling, I guess, but yeah.
Okay, this is a big one, especially for our geography. I live in Ontario. I was in a car accident in Quebec. The guy who hit me is a resident of Quebec. Should I hire a lawyer from Quebec or Ontario? And you said that in your office you have a situation right now which is sort of the reverse.
I've got tons of them. I spoke with somebody a couple days ago who lives in Barrhaven, and they were driving to their federal government job in Quebec, and they were rear-ended in a serious collision. And basically, an Ontario lawyer can help you out if you're a resident of Ontario. Unlike Ontario, where you can sue an at-fault driver, in Quebec you cannot. So all you're entitled to are the accident benefits through your own automobile insurance. And if you're hit in Quebec, you can either elect to go under the Quebec regime or the Ontario regime, talk to a lawyer. When I get these cases, I actually hire an actuary to crunch the numbers to see which one would be most beneficial. Because once you decide, you can't go back in your decision.
But this is a common situation because so many people living in Ontario work in Quebec and vice versa.
Yeah, I have clients who are Quebec residents who are in an accident in Ontario, and they're surprised when they find out they can sue the at-fault driver, and so we can help them out as well.
We covered a lot of ground. lot of topics, and we know that there's probably a topic of yours we missed. So by all means, email us a question. If you have a legal question for Dave Hollingsworth, he's back on the program in 6 weeks' time, and we have an address on our screen. There's a link to ottawainjury.ca on our website, and you're welcome to get a hold of David directly there. Thanks a lot.
Thanks, Leanne.
Catch your breath. Have a glass of water after that.
All right.
Michael.